Now call the fourth case on this morning's docket, case number 118992 in the matter of Michael J. Stutman.
May it please the court, Stan Hazlitt appearing for the Disciplinary Administrator's Office. Mr. Chief Justice, I would like to reserve 2 minutes for rebuttal.
2 minutes is granted.
This is an original proceeding in attorney discipline. The hearing occurred in this case on November 2nd of 2017. Respondent appeared in person at that hearing and with his counsel, Craig Robinson, who's here today. Deborah Hughes appeared for our office, and the respondent has not taken exceptions to the findings of fact in this matter, so in fact, the findings of fact are deemed admitted under Supreme Court Rule 212D. Actually, there were stipulations entered into, and the respondent admitted many of the facts during the hearing. A short summary of the facts. This matter arose out of the respondent's representation of two individuals, boyfriend and girlfriend, HS and TC, in a criminal matter involving a pedestrian who was killed in a hit-and-run accident. That occurred on July 18th of 2015. HS and TC were in a relationship at that time. The police quickly identified them as suspects in the case. And in fact, HS, TC's girlfriend, confessed to the police that she was driving the vehicle that hit the pedestrian that resulted in the pedestrian's death. That happened on July 23rd, some 5 days after the death and the accident. HS was arrested and was charged initially on the 23rd of July. At that point in time, TC was still being investigated for interference with the investigation. In fact, both of them were under investigation for that additional problem. The truck that was involved in the accident was removed to Colorado, and there were repairs being made on the truck. And so to cover up the fact that in fact there had been an accident. The respondent was retained to represent TC and HS on July 23rd of 2015. A couple of days later, he talked to one of HS's girlfriends who indicated to him that she was concerned that maybe HS was covering up, saying that she was driving when in fact her boyfriend had not, because he had some previous legal problems. So that issue, that red flag, was there as of July 25th. The respondent received a $10,000 retainer on July 28th of 2015 for the representation, and on July 29th of 2015, just 1 day later, both HS and TC chose to hire different counsel. They both had their own counsel at that point in time. Out of that core set of facts, the panel found a number of violations of rules, and the first being scope of representation, Rule 1.2. They found that the respondent's representation of TC was for the limited purposes of any contact that TC might have with law enforcement. Remember that HS had already confessed to the crime, but there was still the possibility that TC was going to be questioned by the detectives about this interference with the investigation by getting the truck fixed. And the respondent testified that should there be any contact by law enforcement, then I'm going to be representing TC under those circumstances. The respondent did not obtain informed consent confirmed in writing to the limited representation as required by Rule 1.2c. With respect to fees, the respondent claimed that he earned $7,625 in fees during the 8 days he represented TC and HS. The panel described the respondent's work during those 8 days as preliminary work and noted that he had not actually met personally with HS. I mean, the respondent practices out of Wichita. This happened in, I believe it was Ellis County, around Hayes. And they found his fee to be unreasonable for the 8-day representation. They also noted that the respondent charged in increments, quarter-hour increments. It was either 0.25, 0.5, 0.75, or 0.1. Every single entry was that way. Earlier in this case, after the case had been docketed for investigation, the respondent did make a payment to HS's mother in the amount of $2,375. And last Thursday, because the panel in this case recommended, and we suggested, recommended also that all of this fee be returned. Last Thursday, I received a check from the respondent and respondent's counsel for the remaining $7,625. So that $10,000 retainer has in fact been returned. Panel also found a violation of Rule 1.7, conflict of interest of current clients. Panel found that there was a substantial risk that the respondent's representation of TC would conflict with his responsibilities to HS and the other way around, both ways, and that if in fact the dual representation was indeed possible, which it may not have been, that he needed to get confirmed, informed consent confirmed in writing, which did not happen. There was a finding of a violation of 1.8. That's the conflict of interest rule that deals with current clients. HS did not give the respondent informed consent to the payment of her attorney's fees by an individual other than herself. And finally, a violation of Rule 1.16, termination of representation. This was because of the respondent's failure to timely return unearned fees. His representation effectively ended on July 29th of 2015. The complaint in this case was filed by HS's mother on October 1st of 2015. There have been many attempts to get an accounting and a refund up until that point in time with really no response from the respondent or his office. Our office recommended a 90-day suspension. The reasoning for that recommendation was that we believe that the respondent should not have agreed to represent both of these folks to begin with. It was obvious that there were potential conflicts, and became really obvious at a point in time when people started to suspect that HS wasn't even driving the automobile. We argued, and the panel found that the clients received very little of value, and as a result of this happening, they had to terminate the representation of the respondent and hire counsel of their own. Today, I would still argue that that's the appropriate discipline. The respondent argued for informal admonition. The panel recommended that the respondent be publicly censured, and that the respondent refund the entire retainer of $10,000. As I stated, that's already happened.
Let me ask you about that, because I'm bothered by it. The hearing panel report was dated February of 2018. The payment was made last Thursday. That seems like it's been made more for my benefit than it is for the clients. How do you read that refund? Is there some reason I shouldn't be bothered by waiting 7 months to refund clients' money, which was already late to be refunded?
Well, you could certainly look at it that way, yes. Given the fact that the panel made the finding that just the time period from July until October, when the complaint was filed, was a violation of the rules of professional conduct, and an additional 7 months could certainly be viewed as you just have.
Okay.
Any further questions?
I'm sorry, I just have a couple
Oh,
more
I'm
things.
sorry.
No, well, that was my fault. The panel recommended that the respondent be publicly censured, and I addressed the first thing that they recommended that you do, and that be that the $10,000 be returned. That's been returned. They also recommended that the respondent provide to our office a proposed engagement letter that he would use in the future. We have that. If you suggest or if you order us to review that, to think whether or not, or to decide whether or not we think it's proper, we're certainly willing to do that. They also suggested an audit of the respondent's trust account. I've talked to Mr. Robinson today. They'll do whatever they need to do with the engagement letter should you order us to do that. They're also willing to submit to an audit from our office at any time.
You made the point of, in the final report of mentioning that the billing was done in quarter-hour increments. Are you contending that there's something inherently improper about that?
I think there is case law that states that if you're going to bill a quarter of an hour or a half an hour or 3/4 of an hour, that you have to do that amount of work. Now the panel made note of that on 2 different occasions in the panel report, and I suggest to you that that would be a finding on their part in addition to the fee being unreasonable, but billing in those increments would be unreasonable as well.
Is there a reason for the audit of the trust account?
You know, I don't believe it's stated in the record. I think I think that they felt due to the circumstances here with the money going, that amount of money going in and according to the respondent being earned that quickly, that they that's just speculation on my
I mean,
part.
you don't need an order of this court to go audit a licensed attorney's trust account, as I remember. Is that right? Am I remembering wrong?
Well, I think we need specific cause to go in and look at somebody's trust account, but there's also the rule, your rule on compliance examinations where we draw names randomly. So we really need some specific reason to go in. I suppose you could argue that we have it here, but this is what the panel recommended.
Did I understand? Go ahead.
No, go ahead.
Did I understand you to say you have already received item B, a copy of an appropriate engagement letter, and you have approved it?
No, Your Honor. There was some, Mr. Robinson and I talked this morning about this, and he indicated that that document had been sent to our office. I have no doubt that happened, but I had not seen it. He gave it to me, and if you should order us to do so, we obviously will look at it and make any suggestions, but that has not happened yet.
Very well. Thank you. Justice
What-
Johnson.
What in your proposal addresses the panel finding that on a number of occasions the respondent's testimony was deceptive, inconsistent, and misleading?
I think that's part of what justifies the suspension, Your Honor. I mean, they clearly felt that the respondent's explanation of a potential conflict of interest was either didn't happen or was not explained adequately. And I think that's part of the reason for the recommendation. If you look at standard 4.32, which is what was cited by the panel and coming to its, which was cited by us, I'm sorry, not by the panel. Suspension is generally appropriate when a lawyer knows of a conflict of interest and does not fully disclose to a client the possible effect of that conflict and causes injury or potential injury to a client. And I think all of those things are in play here that was not adequately explained, which is what you're referring to, what the finding that the panel made, that there was more than potential injury because they had to terminate the services of Mr. Stubman and hire a new lawyer. Each one of them had to hire their own separate lawyer when it became obvious that that's what should happen.
I'll now ask if there are any further questions. If that has concluded your presentation.
Yes.
Okay. Any more questions? Counsel, while you're still at the lectern, I neglected to introduce the justice who's sitting in for Justice Rosen. The distinguished jurist to my right with the beard is the Honorable Pat McEnany. He sits on the Kansas Court of Appeals, and before that he was the Chief Judge of the 10th Judicial District in Johnson County. And Judge McEnany, on behalf of my colleagues, I'd like to thank you for helping us out on this matter today.
My pleasure.
Very good. Thank you.
May it please the court, Craig Robinson appears on behalf of the respondent, Michael Stedman. We will split the argument. Mr. Stedman will address the court at the conclusion of my comments, assuming that I don't go over for my 15 minutes. A preliminary statement I'd like to make is that Mr. Stedman takes no exception to the board's recommendation of public censure. Censure brings the conduct to the attention of the attorney. It educates other attorneys about ethical implications of multiple representations in fee agreements or fee arrangements in criminal cases. And it demonstrates to the public that as a profession we police ourselves and are held accountable for isolated instances of misconduct. Candidly, Mike's representation of HS and TC fell below a reasonable expectation of how a lawyer should navigate criminal cases where there are multiple parties that have exposure to prosecution and potential antagonistic defenses. The quick history, and I think it's somewhat relevant, and it's been stated by my colleague, Mr. Hazlitt, is that In the morning hours of July 23rd, 2015, Mike was called by TC. TC was the boyfriend of HS, seeking representation of HS on a vehicular homicide case in Ellis County. HS was in custody but was not charged until the following week. She had admitted her involvement in running over this gentleman, and there was some, and then they arrested her. It was not clear to Mike at the time, but TC was also being investigated because it was his pickup truck. And as facts were later developed, he had a deeper involvement in terms of trying to hide the crime, or at least it was reported that he hid the crime. That was not apparent to Mike at the initial conversation because he said, "My girlfriend's in jail. I need you to represent her. I saw your advertisement on the web," or "I need a good criminal defense lawyer." Mike's honest intent at that time was to try and help both parties because he was not quite, I don't think he was quite sure as to how the two parties' relationship to the crime was. He should have made a clear statement to TC that he would only represent HS. This would have saved him the 1.2 complaint and the 1.7 complaint, but he didn't make that statement. The agreed retainer fee, or the agreed fee, was $20,000, of which $10,000 was to be advanced, and was delivered to Mike on July 28th by HS's parents. That's 5 days later. On the 23rd and again on the 24th, Mike made inquiry to the court and appeared by telephone on bond matters for HS. Unfortunately, after he got her out on the 24th, she violated the terms and conditions of her bond by not reporting as directed on the 25th and was reincarcerated. That obviously created quite a stir because she wasn't out. She couldn't come to Wichita and retain Mike. She was in jail, and that changed the landscape of how Mike was going to proceed forward. The HS parents came to Mike on the 28th, and while it's not uncommon for a concerned parent to want to discuss their child's legal problems, Mike should not have engaged them in any information sharing that he had learned over the weekend, and I believe that would have saved him the non-authorized communication complaint that's guided by Rule 1.8. Mike's failure to timely account and return unused retainer money on a timely basis supports a finding of 1.16. Failure to terminate a representation properly, because he was only in the case not quite 7 days, but it took him several months to refund some of the money. Now, Justice Biles brought up, well, isn't it odd that he took this long to pay the balance of the $10,000? We had previously advanced $2,700 or $2,800 by the time of the panel hearing, because that's what our accounting records showed, demonstrated we owed them. So the panel made a recommendation that we give the entire amount back, and because of the recent Supreme Court cases, it says it's just a recommendation. We didn't pay anything until this week when I said, well, Mike, I think we ought to just pay it, and let's go ahead and do that for the Supreme Court's benefit. So in direct answer to your question, it was done for the Supreme Court's benefit, but it's only at the recommendation of the panel, not an order of the court. So I think that Mike takes no issue with the panel's finding that the fee was unreasonable under the circumstances. He did have some time in the case. We talked about that in the trial. He did make 2 court appearances by phone. He was gathering evidence. Before he could get a handle on what's going on, he was discharged. This was an undercurrent in the case, but at the time of trial. But Mike's preoccupation with his wife's deteriorating health, she did pass away in 2017, and it's not difficult for anyone to assume that he was not at his professional best, nor was he a particularly effective leader of his office. because the staff people didn't know what to do as these people were requesting reimbursement of money. And he just wasn't paying attention, and he just wasn't at his best. And it's not necessarily an excuse, but I think it's easy for one to assume that with his wife's deteriorating health, he just had a lot on his mind and he was involved in day-to-day caregiving. He wasn't paying that close attention as he should have. He acknowledges that, and that is just the fabric of this case. We did, on one of the findings concerning the appropriate engagement letter, we did supply engagement letters to the local investigator, whose name escapes me, that was involved in the local investigation. He said, "I think your engagement letters are not right." So we did a complete series of engagement letters and gave them to him, and I think it was submitted to the local bar and to the discipline administrator's office when the complaint hit Topeka. We would obviously agree to an audit. We were just waiting for the court's order to do that, or we would have, or Mr. Stedman would have set for an audit this summer if the discipline administrator had the resources and the ability to conduct that audit. Why they recommended that, I do not know, but we're not going to quarrel with it. The single incident should not define Mike's service to the profession or his overall service to the public. He is a member of the local lawyers assistance program committee in Wichita. He's appointed to the state board of lawyers assistants in 2013 and still is a member. He's been on the fee dispute committee in Wichita. He's active in AA, Alcoholics Anonymous. He's a sponsor. He's volunteered at local outpatient drug and alcohol facility for a number of years. He counsels other lawyers who are suffering from depression in our community. He's been a member of the YMCA and volunteered for many years, and he teaches a lot of CLE classes on these things. These are the things that I think are worthy of your consideration of his good deeds and show that Mike is worthy of your grace in applying the censure. If there's any questions, I'll be happy to answer them.
You did not take issue with the panel's finding that the respondent was deceptive in his testimony?
I didn't, well, I do take issue with that, but I didn't take exception to it by a written pleading. When I read it in the final order, I don't see the deception. I honestly don't see it. The question that was posed to Mr. Stedman was about a phone conversation that he had from a third party on the Saturday after the HS was put back in jail, where this girl, who was supposedly a friend of HS, called him on his cell phone and said, "I think you need to take," I'm paraphrasing, "I think you need to take a look at the involvement of TC being the real perpetrator of the crime," and it said a lot of other things like that. Now, I don't know whether that's solid evidence that a lawyer should undertake to I think he receives it, but I don't know what he could have done with it on Saturday at that time. So when he was asked about that, I just don't think that either the question was articulated right or they understood it right. He tried to answer as honestly and forthrightly as he could about that fact pattern. And when I saw in the panel hearing report, I was dismayed about it, but Mike and I talked, and I said, well, we're not taking the exception. I really don't want to take exception to that finding, because I think we can explain it at the time that we speak before the Supreme Court. So there's my explanation for it. Mike can give you a more full explanation for his thought process, because that's really kind of what those questions were about. What was your thought process? I didn't think it was deceptive, but that was that panel's finding. You can read it, and you can, I guess, you can conclude for yourself whether or not it was deceptive.
Do we have any more questions of counsel?
Thank you. I'd introduce Michael Stedman.
May it please the court. I apologize for my voice. I'm having a bit of a summer cold. Last stages. I appreciate the time that you're giving me to speak about this, and I want to fully answer this. I think what was said by my counsel, what was also spoken by Mr. Hazlitt, describes a lot of what went on. This happened 3 years ago and a couple of months. This was a investigation. Charges were never filed while I was representing, and this started off with the HA, that was the young lady who had allegedly admitted running over a gentleman and then leaving the scene of the accident. And I was contacted by the boyfriend originally, and that was on a Thursday. By the following Wednesday, I had been replaced by other counsel in Wichita. Now, I think what we were trying to do at the panel hearing was answer questions honestly and accurately as we could. I received a lot of after-hours communication from, this was the boyfriend, and then there was a friend of the young lady that had admitted to running over the gentleman. And these communications, one was the police had stopped by TC's house, and he wanted to know what to do. And I think I received that call on a Friday night after 9 o'clock. The following day, on Saturday, I received a call while I was doing grocery shopping from this friend of the young lady, H.A., and she expressed her concerns. Now, throughout all of this, we were attempting to gather facts, and I certainly fell short by not having a written document about the conflict of interest. And that's something that when I look back at it, it just seems like that week flew by very quickly. And I thought things were going well when we were able to get her out of custody on the Friday prior, and then evidently she was staying with her mother, and they were working together, I thought, pretty well at that point. And then I think the relationship between the mother and the daughter deteriorated. And I did visit with just the mother and her brother on the following Monday or Tuesday. And they traveled down to Wichita and paid half of the retainer. Now, I believe that what the panel recommended is very kind, and I certainly, I think a censor is in order, and there's no excuse for falling below the standards. I take my job very seriously, and to think back that I may have put these parties in some jeopardy by not explaining that and putting in writing, it's still shocking to me that I did not do that. We have forms to do that. I have dealt with that in the past. That is a priority. For whatever reason, it didn't get done in this case. And it caused my clients pain, and it caused them trepidation, and I'm trying my best to make amends for that behavior. There's also speaking to the mother. and the brother, when they came down to pay my fee, and this, I too believe, is a violation, and this is something that I have learned from, and I note the parties were getting along very well, and they were on the same page when I got them out of custody. It just changed, but that shouldn't have been. I should have just gotten the retainer and tried to answer maybe some preliminary questions like what happens next. Not so much any concerns about the young lady. Now, they also touched upon some of the things that is happening in my life, and it was a difficult time for me. And because normally refunds are done promptly. Normally they're done pursuant to a contract I have it's supposed to be within 10 days to 14 days, just depending upon what happens. And this one did not get done. And I don't have any good answer for that. That's a violation. And once again, I am very disappointed with myself. I don't care if I had issues at the time. I think it's important to always note what's going on in one's life. And my wife had a very massive heart attack in 2012 and wasn't supposed to live very long, but she did. She lasted almost 5 years. But it wasn't a pleasant 5 years for her. She was in a lot of pain. And I would do my work and race home basically to do the other things. I had some help there during the day when I wasn't there, but that had an effect on me. And I think for someone that works with lawyers that are depressed, I probably was functioning in somewhat of a situational depression because I really loved this woman and I did not want to lose her. I also want to simply state that that's never an excuse and that's never anything. This is something that I did, and I want to make amends for this. I certainly did not try to deceive the panel. I was trying to answer the question whether this was a lack of understanding of the question or whether it was just not, it didn't come out the way I intended. I was, and the question had to do with this phone call I received on a Saturday from H.A.'s friend. And all I had heard was concerns, and I thought I answered the question, but looking back, obviously the panel felt differently, and I can respect the panel. I think they did a very nice job through everything, and I'm very grateful for that. And you know, I've been very grateful for the opportunity to practice law since 1985. I'm very grateful to the Kansas Bar Association because they helped save my life many years ago when they did an intervention. And since then I have tried to do exactly what they've recommended. And I have a new lease on life because of the Kansas Bar Association. And that's why I give of my time. And so I have a lot of experience, and experienced attorneys should know better, not make these violations. And that's why I believe everything is appropriate in this report. I just wanted to explain a little bit more on this issue about being deceiving to the panel. That certainly was not my intention. My intention was to answer it honestly as I could.
Do we have any questions of counsel? Thank you, counsel.
Thank you, sir.
You've reserved 2 minutes for rebuttal.
Just one quick point, Justice Biles. I don't think I did a very good job of answering your question about why the audit might have been granted or requested. This complaint was filed on October 1st of 2015 because there had not been an accounting and a refund. In November of 2015, the respondent provided the investigator an accounting saying, hey, look, I spent 38 hours on this case and I earned $8,875. The investigator returned that check because he thought, well, I really don't have the authority to be deciding fee disputes. And then in March of 2016, while the investigation was still going on, there was a revised statement by the respondent saying he spent 33 hours earning $7,625. So my belief is that the panel wanted to make sure that the money went into the trust account and that the money remained there. That would be the logical thing, I think. At least the money that had not been earned, according to the respondent, should have remained in the trust account. I have nothing further unless you have any additional questions.
Any more questions? Thank you, counsel. We thank all counsel for your arguments this morning and this afternoon. Clerk will take this matter under advisement. That concludes